We will be beginning at 3 p.m. Eastern in about 6 minutes. 4 minutes. Thank you for joining us. We will be beginning at 3 o'clock Eastern in approximately 3 minutes. Good afternoon, and thank you for joining us. We will be beginning the webinar in about 2 minutes at 3 o'clock Eastern. Good afternoon, and thank you for joining us. We will be beginning the webinar shortly in about 1 minute at 3 o'clock p.m. Eastern Time. Welcome. Hello, everybody. My name is Ronza Othman. I use she, her pronouns, and I serve as the president of the National Association of Blind Government Employees, which is a division of the National Federation of the Blind. Thank you for being with us. This is the National Federation of the Blind and U.S. Access Board webinar on Section 508. Along with the closed captions in the Zoom, we are also using the captioning feature, OneCap app, that can be used for captions at your own pace. We will add the link to the chat available on the mobile and web. Also in the chat is the link to the PowerPoint presentation. After the presentation, there will be a question and answer session. You can send questions now through the Q&A feature on the web or on mobile or through any of our social media channels. Or you can send an email to communications, that's plural, communications@nfb.org. This afternoon, we are very pleased to have kicking us off President of the National Federation of the Blind, Mark Riccobono, with a welcome.
Happy Global Accessibility Awareness Day 2023. I'm Mark Riccobono, President of the National Federation of the Blind, where we know that blindness is not the characteristic that defines you or your future. Every day we work to raise the expectations for blind people because we know that low expectations create obstacles between blind people and our dreams. You can live the life you want, and blindness is not what holds you back. But all too often in society, access barriers, especially in the digital environment, do hold us back. And this seminar is one of our efforts to help eliminate those barriers by educating members of the public and advocates, especially federal employees, on their rights related to Section 508 and the work that we have been doing to raise expectations and get that piece of the law to be more effective for employees with disabilities and the general public needing to access government services, but also to improve the government's work to implement accessibility in a broad way. I'd like to thank our Association of Blind Government Employees for hosting this, along with the United States Access Board. By working together and understanding the advancements that we collectively have helped push forward related to Section 508, we can continue to push the government even harder. We should expect more out of the government. We should expect our government to lead the way in terms of full participation for all people with disabilities. I think working together we will get there, and your participation in this seminar will help us build that community of accessibility together. So ask all the hard questions, gather all the information you can, and then let's work together to continue making progress toward our shared vision for the future of Section 508 and accessibility in the government, and that accessibility will drive the rest of the nation. Thank you for being here. Thank you for your work, and let's go build a more accessible America.
Thank you, President Riccobono. This afternoon, we have a number of areas that we're going to cover. I'm pleased to be able to share with you our panelists who are among the leading experts in this country on Section 508. Kathy Ng serves as a senior ICT accessibility specialist with the U.S. Access Board. She provides technical assistance on Section 508 with a focus on conformance testing. Kathy is co-lead of the ICT testing baseline portfolio, co-facilitator of the WC Accessibility Conformance Testing Task Force, and chair of the Best Practices Subcommittee in the Accessibility Community of Practice of the Chief Information Officers Council. Kathy joined the Access Board in 2018. We also have with us Tim Elder, who is a civil rights litigator focusing on disability discrimination cases and founder of TRE Legal Practice. He has helped secure injunctions against testing entities for their failure to accommodate disabled students, negotiated groundbreaking settlements with publicly traded companies, tried employment discrimination claims before juries, and argued before federal trial and appellate courts. Kathy will begin this afternoon's presentation, and then she will hand it off to Tim. Once the presentations conclude, we will open it up to your questions and answers. Take it away, Kathy.
Thanks, Ronza. Hi, everyone. I'm Kathy Ng from the Access Board, and thanks to NFB for inviting us at the Access Board to be part of your Global Accessibility Awareness Day webinar. From personal experience, I think there's some folks out there who might not know who the Access Board is. So I'm just going to start out with a quick overview about what this very small agency does. The Access Board is an independent federal agency that promotes equality for people with disabilities through leadership in accessible design and the development of accessibility guidelines and standards. The Access Board develops and maintains design criteria for the built environment, transit vehicles, information and communication technology, and medical diagnostic equipment under the Americans with Disabilities Act of 1990, or the ADA, and other laws. It also provides technical assistance and training on these requirements and on accessible design, and continues to enforce the Architectural Barriers Act, or the ABA, that apply to federally funded facilities. So on this next slide, we're going to talk a little bit more about how the Access Board is directly related to the Information and Communication Technology Accessibility Standards, or as we know it, Section 508. So the Access Board wrote the Section 508 standards of the Rehabilitation Act, and they were first released, the first technical standards were released in 2001. And since then, they have been revised in 2017 to incorporate the Web Content Accessibility Guidelines, which are international web accessibility standards. And these revised 508 requirements became enforceable in 2018. So the Access Board provides technical assistance on and respond to questions about the Section 508 standards and guidelines. The Access Board has no authority to enforce Section 508 accessibility compliance for other agencies. Each agency enforces Section 508 for themselves. So on this slide, we have a little bit more about Section 508 of the Rehabilitation Act. Section 508 requires that federal departments and agencies, including the U.S. Postal Service, procures, develops, maintains, or uses information and communication technology that is accessible to people with disabilities, and to give employees and members of the public with disabilities access to information that is comparable to the access available to others without disabilities. Again, Section 508 was revised in 2017. So if you were familiar with the original ones from before 2017, you might want to catch up on what the current requirements are. And those are available on our website that I'll provide later on in this presentation. So the first thing when we're trying to figure out is Section 508 applicable to a product is to determine if it is information and communication technology, or ICT. So we have a definition of ICT as information technology and other equipment, systems, technologies, or processes for which the principal function is the creation, manipulation, storage, display, receipt, or information of electronic data and information, and its associated content. Examples include computers, kiosks, telecommunications equipment, multifunction office machines, software, websites, videos, and electronic documents. One significant difference from the original 508 requirements to the current 508 requirements is that we explicitly call out that 508 applies to electronic documents. There are exceptions. So that's one other thing to consider after you determine that it is ICT. And we've got those general exceptions outlined online again on our website. So the categories of ICT that are covered in Section 508 are electronic content, hardware, software, and support documentation and services. Next, I'll go over some of the examples of IT and ICT that fall under these categories that Section 508 applies to. So for a typical office worker, here's some examples of how you'll encounter IT and ICT in your daily workday. So one of the categories that we cover is hardware, and we've got a picture of someone using a laptop. The laptop itself is hardware. Other categories of hardware include kiosks and even your multifunction printer at the office. Next, we'll move on to once you turn on your laptop, you're most likely going to use some sort of software application. The software has Section 508 requirements. And some of these, applications include Microsoft Office products like Word or Excel. And generally, software is an application that is used to create some kind of information that falls under the next category that I'm going to talk about, which is electronic content. This is any type of file format that contains information and is digital. So examples include a website, like I said, the document, a spreadsheet, even this slide deck. If this was shared with its attendees in a digital format, it would have to meet the Section 508 requirements. And then we've also got a category under Section 508 for supporting documentation and support services. And this is electronic content and communication in support of an IT product. So if you have a contract for a calling service like your IT support, there are requirements within Section 508 that any documentation has to be available in a 508 conforming format. And if there's an alternative format like Braille requested, then it needs to be provided as well. So one of the things that we have been working on at the Access Board in partnership with General Services Administration is how to improve Section 508 testing. Testing is necessary to determine whether ICT conforms to Section 508 standards. How do you know if something meets the requirements? You test it. But one of the challenges with testing is having consistent testing because interpretation of standards vary. It depends on who's testing, that they may come up with a different result because they believe the standard requires something different from another party that's been testing. There's also a variety of test methodologies, which include manual. This is where a human tester evaluates the ICT and makes the decision of whether it meets the requirements or not. And the benefits of this is that often human judgment is required to determine whether something meets the 508 requirement, but it takes a long time to cover all of the content and can be very slow. Another type of testing methodology is automated, where we have a tool that will make the determination of whether the content meets the requirements or not. And this is much faster than a human tester, but it's limited in testing capability because, as mentioned before, the automated tool can't make the human judgment of whether the content alternative is equivalent to the content. And then there's a hybrid approach, which combines the manual testing, which includes the human judgment, and the automated testing, where the benefit is that it can cover the content much more quickly. And the combined hybrid approach is probably the more ideal, but there are still some deficiencies there. And all of these different variations of testing methodologies and different interpretation of the standards leads to inconsistent test results, which is a challenge for the agencies and for the product providers to understand what does it mean to provide ICT that is Section 508 conformant. So what we've created is something called the ICT testing baseline portfolio, where GSA and the Access Board are leading this effort to establish the foundation for test results to be consistent across any testing methodology. And this is to help validate that test processes are covering all of the Section 508 requirements and producing consistent test results that are accurate. So the idea with the testing baseline, it's kind of simple, but not so simple. It includes all of the Section 508 requirements, what in the content or in the ICT needs to be checked to meet those 508 requirements. And that's it. It's a document that describes the standards and what to check to determine conformance. So for web, the revised 508 requirements are essentially the Web Content Accessibility Guidelines version 2.0. And in the baseline, each of these WCAG requirements are described as and includes what to check to determine if that requirement has been met. This ICT testing baseline portfolio will eventually include a baseline for all of the ICT that are included in Section 508. At present, we have completed a baseline for web, and we're working on updating that. And we also have a draft for baseline for documents. And then future plans include a baseline to develop a baseline for software and hardware and any other ICT that the Section 508 requirements will cover. So as I mentioned, we have an ICT baseline for web. This slide 14 includes a link to that information on the Access Board website. We also have the baseline alignment framework for web, which is being led by General Services Administration, or GSA. What this alignment framework will include is hundreds of test cases for each of the baseline tests, so that test processes and test methodology owners can go through the test cases and provide test results for them. And what we will do is compare the test processes results to what the baseline results expected. And if they're in alignment, meaning that, if we expected a pass and they pass the test case, and similarly for fail and not applicable, then we can determine that the test methodology or test process does align, and it would produce the same expected test results as the baseline would for actual real-world testing. The ICT baseline for web is a best practice under the Federal CIO Council's accessibility community of practice. So I'd encourage any of the federal agencies that are listening in today to take a look at the ICT baseline for web. Get in touch with the Access Board if you have any interest in learning more about it. And so next, I'll just talk about some recent 508 activities that have occurred to give you an idea of all of the current events that are happening. In 2022, the U.S. Senate sent letters to several federal agencies, including the Veterans Administration, Department of Justice, GAO, and GSA, all regarding Section 508 and asking about the conformance and compliance at agencies. There was also a Senate hearing that covered accessible federal technology for people with disabilities, older Americans, and veterans. And there's a link to the video if you're interested in listening to or watching the Senate hearing. And I'd encourage you all to check it out. There's a lot of good information in there. And then there's also a PDF report that was produced by the Aging Committee on Section 508, and it's called Unlocking the Virtual Front Door. And it covers a lot of the activities that the Senate engaged in related to Section 508, including some recommendations to improve Section 508 conformance. Another new, fairly new activity that came about recently was that there are new requirements for Section 508 assessment and reporting. And this is officially under the Section 752 of a Consolidated Appropriations Act for 2023. The Department of Justice recently, in February of this year, released a Section 508 report to Congress and the President. This was a joint report produced in collaboration with GSA and DOJ, and it was a report describing the current conformance of agencies. As I mentioned earlier, there are new Section 508 reporting requirements from the Consolidated Appropriations Act of 2023. In that Appropriations Act, there were a few things that were identified as new requirements, including the Office of Management and Budget, OMB, in consultation with GSA and the Access Board, published updated Section 508 assessment criteria. April 8th has passed and we have met that deadline. I'll provide a little bit more information about that in the next slide. Federal agencies that must meet Section 508 will have until August 11th to submit their responses and reports and data to provide their status on the revised assessment criteria. And at the end of the year, by December 29th, GSA, in consultation with OMB, will provide a report to Congress with the assessment of agency compliance. And so the Section 508 assessment overview on this slide includes a link to the Section 508.gov website where you can get some more information about each of the criteria that are being asked of federal agencies. There are 105 questions about agency compliance, and these questions cover conformance test results, accessibility maturity, and questions about the 508 program and support. And again, there's a link on this slide to that page to get more information. And now I'm going to turn it over to Tim.
Okay. Thank you, Kathy. It's exciting to hear about some of the recent activity going on at Access Board. My name is Tim Elder. I'm the founding attorney at the TRE Legal Practice. We're a law firm based out of the San Francisco Bay Area that really focuses on disability rights and, in particular, digital accessibility and impact cases designed to advance those digital rights. Kind of moving forward to the next slide. As you heard, Section 508 of the Rehabilitation Act requires accessible technology, ICT, or as I tend to remember it, electronic information technology, EIT, which is included in ICT. And that applies to two groups of people, federal employees, as we heard, and members of the public seeking information and services. While I'll be focusing on the rights of federal employees today, please keep in mind that much of what I'm going to be talking about is equally applicable to members of the public who are seeking information and services. Both groups use the same administrative complaint procedures and the same statutory rights to enforce their complaints. Kind of moving to the next slide here. Let's quickly talk about what Section 508 is not. We need to clear up some confusion about how it overlaps with other anti-discrimination laws. There is this concept of reasonable accommodations and the prohibition on employment discrimination. That is covered by a completely separate section of the Rehabilitation Act. It's under Section 501 of the Rehabilitation Act. And that section adopts the standards of Title I of the Americans with Disabilities Act, which is this traditional employment discrimination prohibition that most employers are familiar with, and the concept of reasonable accommodations. This body of law is processed through administrative complaints that go through the EEOC, or the Equal Employment Opportunity Commission. I would say that it's important to keep these 501 claims as distinct and different from Section 508 claims, as we're going to see in a minute. That being said, most of the 508 cases that I see on behalf of federal employees tend to have some overlap with a Section 501 claim or a fact pattern that could be the basis for an independent Section 501 a claim for failure to accommodate or other form of discrimination. Moving to the next slide. It is important to remember that reasonable accommodations do not excuse compliance with Section 508. So there is a concept of alternative means under Section 508, but that does not mean that if you provide reasonable accommodations to an employee, you no longer have to comply with Section 508. You must comply with Section 508 unless there has been a documented contemporaneous undue burden to comply with the technical requirements. And given the undue burden analysis, it's on the agency to demonstrate it, to prove it, and that it considers a lot of the resources that the agency has at its disposal in the budget. I don't think it's a very large exception to 508. It's an affirmative defense in a very narrow set of facts. And most agencies, most of the technology they're using would not fall into this exception, particularly where a lot of technology is being procured and the cost has already sort of been implemented, and it's really enforcing a remedy in the contract with the vendor to make sure that they've delivered what they said they are going to deliver, or to get them to remediate in accordance with the contractual terms. Let's move to the next slide. As Kathy mentioned, there are technical regulations that explain how to comply with Section 508. And the most notable development is that in 2018, the technical standards adopted the WCAG WCAG 2.0 standards for web. And given the modern workforce technology trend of delivering everything in the cloud through a browser-based interface, this has a major impact on the technology that a lot of workers and federal employees are using, and how to comply with it. So we do have a nice consistent standard here that websites need to comply with, that also apply to the websites that federal employees are using in their job. Frankly, I can't think of any technology that would be at play in the federal workforce that wouldn't be covered by Section 508. You know, that someone's using on a daily basis in a regular way. I think it really applies to almost all technologies that are at use by federal employees. I want to give you just a quick sample of some of the kinds of complaints that our office receives. Some of the popular categories of technology. We get a lot of complaints about HR training and testing modules. So these are systems used to test or train the federal workforce through any number of online resources. We get complaints about collaboration and sharing tools. Often this involves a customized interface from SharePoint or some other file sharing or collaboration system. Repositories of PDF documents, libraries, or archives, so a large chunk of PDF material that is not accessible, doesn't have table formatting for charts and data. Case management and database systems that are sort of proprietary to the agency's purpose. Healthcare portals. So these are websites that federal employees use to access their healthcare benefits. While it's a third-party website, the service of the benefits for the federal employees has been procured or is being used by the federal agencies to provide healthcare or other benefits to those federal employees. We've received complaints about security hardware for facilities or computers, right? So pin pads on a door lock or two-factor authentication fobs to get into a computer. It's just some of the technologies that we see in a very practical way that, if not made compliant with 508, can really block equal opportunity for a disabled employee to fully participate in the job and to be as efficient as they possibly can and productive as they want to be in their role. Moving to the next slide, let's talk a little bit about complaints under Section 508 and the differences in particular between 501 complaints and 508 complaints. And for just a fun fact to celebrate Global Accessibility Awareness Day, we've got an image here of a tale of two cities, with one city being very developed on one side and one sort of area not being so developed on the other. And for those who want to have some fun, check out the alt text description in the PowerPoint. It was the image. This image itself was generated by ChatGPT upon a text query, and then ChatGPT was asked to describe the image, and then it was checked by a human, and it was very interesting, sort of intersecting with Kathy's point about automated and manual. It's a very interesting sort of development to see how automated mixed with manual can be used for alt text descriptions and remediation, and just sort of a fun exercise. But not so fun is the actual disparity represented in the picture, which is under 501, we've got a very robust and well-defined process for filing reasonable accommodation claims or discrimination claims under 501 and the EEOC. Regardless of what agency you're at, your complaint goes into the same window at the EEOC, and the same regulations apply. However, unfortunately, under Section 508, it's up to each individual agency on how to process the complaints. Each agency is supposed to have Section 504 regulations that in turn are the procedures to be used when filing a Section 508 complaint for inaccessible technology. The problem is that window is different and looks different and has different hours of operation and different contact methods for every single agency. And some small agencies may not have even promulgated their 504 regulations to date. So it can be a bit chaotic when someone's trying to file a Section 508 complaint to try to figure out where they go. The other thing to remember is that these two paths are not mutually exclusive, and they can proceed in parallel. So I'll give you an example. Let's say an agency has a case management portal that's inaccessible and not compliant with 508. A blind applicant for the job that needs to use this software, and they could do it if they were given a reasonable accommodation, say a human reader or assistant. The applicant is eventually not hired for the position because of concerns about the efficiency or the budget of having a human reader and two positions, or two individuals, right, assigned to a position that was designed for one person. That fact pattern could be the basis, certainly, for a failure to hire, failure to accommodate discrimination case, subject to damages and all of the employment discrimination remedies, and that would go through the EEOC. But at the exact same time, that same fact pattern could be the basis for a Section 508 claim that then goes through a separate set of complaint procedures to remediate and deal with the inaccessibility of that case management system. And that's completely independent of what happened to the employee and the merits of the discrimination claim. I don't tend to refer to Section 508 as a discrimination claim. I tend to refer to it as an access or a technical compliance claim. Moving to the next slide. Let's talk a little bit about what happens when a federal employee actually finds the right window where they're supposed to submit their 508 complaint. What happens? Well, a couple of things tend to happen. First is it's very hard for the federal employee to even find the right window, right? Where are the 504 regs? You have to go look in the Code of Federal Regulations for that specific agency and locate it. There's often no information on the website. HR often doesn't know where this stuff goes. There may be no internal memorandum or documents explaining on how the agency is supposed to process it. So it's often that employees just never find it in the first place. Second, a lot of employees, either out of frustration or confusion, mistakenly file their 508 complaints with the EEOC in connection to their 501 rights. Now, the unfortunate reality is that eventually EEOC will dismiss any direct 508 claims because it doesn't have jurisdiction to handle that. Each agency is really expected to handle its own Section 508 procedures and do the investigations and respond to complaints and align them with their 504 procedures. And those 504 procedures are typically used for complaints from members of the public who have a access concern with a program or activity that's being offered to the public. The unfortunate reality from this disparity is that these 508 complaint procedures end up resulting in underutilized and underdeveloped infrastructure. So federal agencies don't have formal channels to process complaints when a 508 complaint finally does end up on the right desk. And then as a result of that, many federal employees never receive a response to their duly filed Section 508 complaint. Next slide here. Let's talk a little bit about the Orozco litigation, which resulted as sort of part of this problem here. Up until very recently, the prospect of enforcing Section 508 was not very good. A recent ruling from the DC Circuit Court, the federal appellate court for the DC Circuit, has changed this trajectory. And I'm really proud to be representing Joe Orozco, a member of the National Federation of the Blind, who brought about this change in the case law. Mr. Orozco is a blind intelligence analyst for the FBI. He had brought a federal lawsuit after the FBI failed to respond to his 508 complaints about inaccessible technology in the workplace. It's important to note that Mr. Orozco did everything he really could do to exhaust his administrative remedies before filing suit. He had filed a complaint with the appropriate 504 channels. He had even gone through the EEO procedures with the 508 issue, and he had even sent a courtesy copy to the CIO of the agency just to make sure we had covered all the bases were covered, right? Where in terms of can we get this complaint addressed? Unfortunately, though, in his case, the federal court incorrectly the trial court incorrectly dismissed Mr. Orozco's case on grounds that had been popular with a lot of other federal trial courts, saying that federal employees had no right to judicially enforce their Section 508 remedies. And so we appealed that decision, and this is the next slide. The DC Circuit reversed that holding from the trial court, as well as the logic that a lot of the other trial courts had similarly relied on, and the appellate court clarified that no, federal employees absolutely have a right to enforce Section 508 obligations in federal court when an agency doesn't respond, in particular, to their administrative complaint. And so the main thing to take away from the holding is that, number one, this applied to injunctive relief, which includes attorney's fees. But this was employee who is seeking remediation of the technology to make it compliant with the technical standard. And the other thing that the court had noted is that Mr. Orozco had in fact tried to file an administrative complaint ahead of filing suit. So I think going forward, we can say that at least for claims for injunctive relief and where the employee has filed a 508 administrative complaint ahead of filing, these claims are good to go to enforce the equal access to technology. The citation to the case, for those who want it, it's in the PowerPoint slide, but it's Orozco v. Garland, and it's at 60 F.4th 684. And again, in the PowerPoint slide, it can be found. This is a very recent decision from 2023. There's a couple practical results that I think will follow from this Orozco decision from the DC Circuit. First, more attorneys are going to be willing to accept Section 508 claims for injunctive relief. In the past, those claims were typically just lumped in with 501 or reasonable accommodation claims, and they were just sort of a tag-along claim. I think, and because of the court's resistance to letting 508 claims go on forward, there was a lot of resistance to attorneys taking those claims. So now I think we will see attorneys that are traditionally oriented to civil rights and injunctive relief much more willing to take these 508 claims to enforce the rights of federal employees in terms of remediating inaccessible or non-compliant technology. I think another practical result is we're going to see federal employees that actually are filing their own complaints or judicially enforcing these claims when agencies fail to respond. So when a complaint goes unanswered and just falls into the administrative abyss, the more employees will have a recourse to get the remedy they seek. And the third thing, which maybe is more of a hope rather than a absolute prediction, is that more agencies will focus on compliance and robust review of their technologies so as to avoid oversight by federal judges and obviously attorneys' fees and the expense of failing to remediate or failing to comply. Next slide, I want to show just a quick checklist for any federal employees who are thinking about how they might take advantage of this Orozco ruling and start to advance their own Section 508 rights. So first of all, you need to consider the remedy you're looking for and whether injunctive relief and remediating and fixing the technology is the primary aim. If you're looking for money damages or a promotion or other changes to terms and conditions of employment, you probably want to look at 501 in the traditional EEOC framework. Second thing is, if you want to enforce, you need to find your agency's 504 complaint regulations to figure out where it is that you would file your 508 complaint. Then you need to draft a complaint that addresses the technology. It doesn't have to be a lawyer complaint. It could be a complaint drafted by a lawyer. It can be something pretty informal, but a written complaint that addresses the technology that is of concern and how it does not comply. I would recommend documenting either through a video demonstration or some other media that shows how the particular technology or the functionality is non-compliant. I would even encourage using the access board's ICT baseline testing as an outline for compliance. It's great to use it for testing, but I think these could be useful tools for demonstrating non-compliance in a complaint. So consider using those baseline standards as they come online. There's already one for web for those who want to use it in a complaint. Finally, take your drafted complaint and mail it or submit it to the contact that's listed in the 504 regulations for your specific agency. Another best practice might be to send a copy of that complaint to the CIO or the technology head of the agency, since they're probably, from practical purposes, the authority head that's going to be looking at the remediation of the technology. And finally, just wait for the time that's allocated for the agency to respond. And if the agency doesn't respond or adequately resolve the complaint in the time allowed, or if no time is allowed and it's some reasonable amount of time, then consider bringing it to federal court or consulting with civil rights attorneys to see what might be done to enforce those civil rights. And on the next slide, I have provided something that our firm is developing to kind of make this easier for federal employees to find the right window for 508 complaints. We have a website here. It's tralegal.com/section-508/ so tralegal.com/section-508/. We're going to be posting the 504 regulation citations and information to help guide federal employees to file 508 complaints with the respective agencies. So this is a work in progress. It's still coming soon. We do have a summer law student extern who's helping with us over the next couple of months to kind of fill this out. But this could be a useful resource for federal employees as we are moving ahead and folks are looking for that right window and that right place to make sure their complaint is filed. So with that, I encourage everyone to consider filing more of these Section 508 complaints, at least with the agency, to let them know that where there are problems, and ideally giving them the opportunity to remediate and correct those in the first instance, so that we can have more compliance in this field. And with that, I'm going to turn it back over to Runza so we can start some Q&A.
Great. Thank you so much, Tim, Kathy. As we move into the Q&A, everyone will remain on mute. However, you can still send questions through the Q&A feature. This is available on both the web and the app versions of Zoom. Or you can email questions to communications, that's a plural, communications@nfb.org. Unfortunately, not all questions can be answered during this session, but we will be reviewing all questions for follow-ups and possibly future presentations. So looking at the Q&A, there are a number of really interesting questions, Tim and Kathy. And first one, a couple of the questions want to know about, does what we described today apply to private industry and or state and local governments?
I can answer that. Yes, in some cases, many states have adopted Section 508 as their standard. So it absolutely applies to every federal agency, but it also applies equally in some states. So for example, California, I believe Missouri, there's several states that have adopted Section 508 as their own state government standard and can be enforced at the state level as well.
Okay. Thank you. So the follow-up question came in. Could you explain how this applies to corporations and nonprofits?
Kathy, do you?
Sure, I can offer that Section 508 as written is a requirement of federal agencies. But as Tim mentioned, some other non-federal entities have adopted Section 508. And we get technical assistance questions at the Access Board a lot asking us, do we have to meet Section 508 requirements? And then it's a matter of checking that entity and what their accessibility policy is. So if you have a specific private organization in mind, I suggest checking what that organization and asking what are the accessibility requirements for that organization.
And I would say for private entities, if you are selling to the government at all, there's a pretty good chance that this applies to you, and that there's some hook in the contract that requires your product that you're selling to the government to comply with the Section 508 standards. That is true in many cases. I think by now the federal government's pretty sophisticated about putting 508 compliance into a lot of its procurement language. So if you're planning to sell to the government, you really should be taking these requirements very seriously. I'll also say that, and that's true for the states too, a lot of states are putting these in their procurement requirements. Even there are other hooks with federal funding that can sometimes trigger the Section 508 obligations as well. So procurement funding, states doing the same thing. That's when it typically applies. But even under the Americans with Disabilities Act, it's the same YCAG standard for the most part. I think most consultants and folks would agree that that's going to be the measure of whether the law has been violated or not.
Thank you. There are some questions around the timing. Tim, you specifically talked about if the agency doesn't respond to a 508 complaint or make something 508 compliant within a reasonable time, then the individual has, may move forward. What constitutes a reasonable amount of time?
Yes, that's all the famous question. I guess the famous answer is it depends. But in general, the 504 regulations often have a timeline by which they will respond to the complaint. Sometimes that's through a report investigation or like a ROI or something. I don't think just an acknowledgement is sufficient, but like actually responding to the concerns is with proposed remedy and a finding on the merits. That can vary with each agency's 504 regulations. I've seen 180 days often as sort of a default. But if you don't have the default in the regulation, then it's up to the case law. And I have seen cases that say, X number of days or X number of months might be a presumptively unreasonable delay for responding to a complaint. I'd be kind of surprised if it was ever less than 180 days, since that's what most agency regulations have. But I think if you wait 3 years to respond, that seems a pretty easy case to make for unreasonable delay. So again, there's no right line, but that's kind of where things are at the moment.
Okay, thank you. How can an agency address 508 and legacy applications where the technology that it's built on cannot be made 508 compliant?
I'll try to take that one first, Tim, if you don't mind.
Yes,
So
please, yeah.
It's an interesting question. Old technology that can't be made accessible, we certainly have encountered that in the past, not so much recently, but more so when the original 508 requirements came out, probably in the early 2000s, we encountered some of that. And it definitely is a problem. We even see some command line interface technology that presents accessibility issues, and the technology itself doesn't have the ability to add accessibility features. It's a challenge for sure. That's some discussion required as to will that technology be updated anytime soon? If you are maintaining any information on it, Section 508 absolutely applies to it. If we're looking at legacy systems that are not being maintained and just staying up for records. That's another consideration. Certainly, we want everything to meet Section 508 requirements and to be accessible, but this might be a deeper conversation as to strategically looking at updating and modernizing the technology, if that's a solution. And if it isn't, then we need to look at how can you provide that information in an accessible alternative way.
Thank you. Kathy, I think this next one is for you. Does the Access Board have any plans for a refresh or adopting a more recent version of the WCAG? The thought is that 2.0 is very out of date, and so we should be looking forward to other versions of the WCAG.
Yeah, we get that question a lot, especially with 2.2 on the horizon. We currently don't have any rulemaking planned to update Section 508. It's certainly something that we want to keep on top of. We know that WCAG is being updated even to an entirely new version of 3.0, but that's not coming anytime soon. 2.1, definitely the versions of WCAG that include additional success criteria to improve accessibility of mobile apps and accessibility for cognitive disabilities are definitely important. We encourage agencies to go beyond 2.0. 2.0 is the minimum accessibility requirement. So agencies are absolutely encouraged to go further and above 2.0 to address the 2.1 success criteria in their accessibility.
Thank you. Can someone clarify the requirements to report the process of accessibility or not to report for independent agencies and their adherence to Section 508? Also, similarly, there's a question about whether DoD and law enforcement agencies are required to adhere to Section 508. And there's a note that somebody shared that some say they are not required to adhere to 508, but they've adopted a 508 policy that says that they would. And so is there any, do the complaints procedures and such apply? So multi-layered question.
Well, I can address the first part. Certainly, Department of Defense and the intelligence community agencies, Section 508 would apply. There are exceptions for national security systems, but as I've heard from several in the intelligence community, they don't automatically just apply that exception. In the intelligence community, they make a great effort to meet the Section 508 requirements and to provide accessible ICT. So there's no exception in Section 508 for law enforcement agencies. There's no fitness for duty exception either. That's something we've also heard. There's no waiver in Section 508 that automatically exempts agencies that perform those types of duties.
Okay. Does Section 508 apply to entities that receive federal funding similar to 504?
So that's a really good question. It can depend on the grant or the conditions of the federal funding. So a lot of times, when there's a 504 provision of federal funding, some technology is involved and it's not accessible. You can raise a complaint under Section 504 and say, hey, this technology is not generally accessible under the 504 claim. And then you can sort of point to the Section 508 standards as a basis to show that 504 has been violated because the 508 standards were not followed. But so it's a little bit tricky to answer that question precisely and say absolutely no or absolutely yes. But it's not as if you would bring a direct 508 claim against an agency. I'm sorry, against a recipient of federal funding. So the answer is, I suppose, not really, but at the same time, that legal obligation under 508 can kind of be applied to some extent through the 504 obligations, if that makes sense.
Thank you. We did get a comment in via email, and we're winding down. Each agency receives their own 501 complaints for investigation, and then after that, it does go to the EEOC. So similar, I think the person was making a comment on the similarity between 508 and 501, that the agencies are both responsible for administering the administrative process. But in 501, after the investigation, and if the person doesn't elect a written decision, then it can go to the EEOC. So I think that was worth noting. I know there are a lot of other questions. Unfortunately, we are now at the end of our time together. Thank you very much for being with us. There are several resources available in the presentation PowerPoint. The link for that has been saved in the chat and is also available on the event landing page. We will also share that link with the recording of the webinar as well as the transcript. If you are interested in information about the Access Board, please do visit the Access Board's website. There are a lot of different resources there that may be helpful to you. If you are interested in information related to civil rights, I'm sure Tim Elder would be happy to hear from you, and he shared his website where the catalog of federal agency information will be added soon. And finally, if you are interested in information about the National Association of Blind Government Employees or the National Federation of the Blind, you can feel free to reach out to me directly at rothmanjd@gmail.com. That's rothman, OTHMANJD@gmail.com. Thank you very much. We are so grateful that you joined us today. Thank you, Tim, and thank you, Kathy. We hope that you found this webinar educational and informative. Let's go build a more 508 compliant world where people with disabilities can engage with their government and their employers on the same terms as the disabled community. Thank you very much.
Thanks, everyone.